Hello there, all my silent friends who have carefully invoked the right to remain silent. In this video, let's talk about why your silence could be used against you in a court of law. In one of my previous videos, I discussed how to properly invoke one's right to silence and to legal counsel. Some viewers commented that one's silence can actually be used against them according to a relatively recent Supreme Court ruling on the case of Salinas versus Texas. So let's take a closer look at this issue in this video. Under what circumstances can one's silence be used by the prosecution in a court of law? First, let's take a very quick look at the key facts from the Salinas versus Texas case. The most relevant facts for our discussion are the following. Mr. Salinas was talking to the police voluntarily pre-arrest and pre-Miranda warning. In other words, Mr. Salinas had not been arrested or charged, he had not been given his Miranda warning, and he was answering police questions voluntarily in a non-custodial setting. And in the process of doing so, he voluntarily answered a number of police questions until the police asked him about his shotgun. And at that point, Mr. Salinas became silent, and according to police reports, he appeared visibly nervous. But when the police officer continued and moved on to questions involving other topics, Mr. Salinas started to answer police questions again. So the prosecution argued in court that Mr. Salinas' silence to those specific questions regarding his shotgun was indicative of his consciousness of guilt. So here the question, of course, is whether the prosecution should be allowed to make that argument in court, because one's silence should be under constitutional protection, as one would imagine. This question reached all the way to the Supreme Court, and the Supreme Court ruled in a 5-4 decision that in this case, the prosecution was allowed to use that silence in court. And now let's take a more careful look at the Supreme Court decision. But let me say this first. The key issue here is not whether Mr. Salinas was actually guilty or not. The key thing that is being considered here is whether or not someone, in fact anyone's silence, should be admissible in a court of law or not, and whether this silence should be used by the prosecution in court and why or why not. So what did the Supreme Court say in this case? Simply put, 5 justices, Justice Alito, Roberts, Kennedy, Thomas, and Scalia, were of the opinion that the prosecution was allowed to use Mr. Salinas' silence and argue in court that the silence was indicative of guilt. But although these 5 justices' judgment agreed, their reasoning and rationales diverged. Justice Alito, Roberts, and Kennedy were of the opinion that the reason that the prosecution could use the silence was because Mr. Salinas never invoked his Fifth Amendment rights, and as such, his silence was not under constitutional protection. The justices argued that the Fifth Amendment is not automatic and self-executing. One has to invoke it in order to trigger constitutional protection. And by the way, this is something I specifically talked about in my previous video, so please check it out. I'll put a link on the screen. But the point here is, the 3 justices said because Mr. Salinas never invoked, so his silence was not protected, and therefore the prosecution could comment on it and use it in court. Now, Justice Thomas and Justice Scalia were also of the opinion that the prosecution in this case was allowed to use this silence, but their reason was different. Simply put, they said, even if Salinas had invoked his Fifth Amendment rights, the prosecution should still be allowed to use his silence because the Fifth Amendment, and I quote here, should not be extended to a defendant's silence during a pre-custodial interview, end quote. As such, Thomas and Scalia had a very strict view and interpretation of Fifth Amendment rights. So these 5 justices together, Alito, Roberts, Kennedy, Thomas, and Scalia, concluded that the prosecution in this case was entitled to using Mr. Salinas' silence in court, although it is important to note, as we have noted already, that their reasons differed. What about the other 4 justices? Well, they dissented. Justice Breyer, Ginsburg, Sotomayor, and Kagan were of the opinion that Mr. Salinas should have been protected under his Fifth Amendment rights, and that to allow the prosecution to use a suspect's silence, even if it is pre-Miranda, pre-arrest, and non-custodial, would place the public in an impossible predicament. And this is because when one is faced with police questioning, one can only either answer or not answer. If what one says can be used against them in a court of law, and if their silence can also be used against them in a court of law, then the public is simply faced with a damned if you do and damned if you don't dilemma. And that is why these 4 justices dissented. Nevertheless, overall it was a 5-4 decision that in the Salinas versus Texas case, the prosecution was entitled to using Mr. Salinas' silence in court. So what are the implications of this ruling? Should we just forget about the Fifth Amendment and never bother to invoke it? Of course not, because when we look at the Supreme Court decision closely, and I'll put a link of the full text below, we can infer, although they didn't state this outright as a fact, but we can infer as best as we could, that 7 of the 9 justices would have agreed that the proper invocation of the Fifth Amendment should forbid the prosecution from commenting on the suspect's silence in court. We can infer from the decision of the Supreme Court that Justice Alito, Roberts, Kennedy, Breyer, Ginsburg, Sotomayor, and Kagan, that these 7 justices would most likely support that as long as one properly invokes the Fifth Amendment, their silence should be under constitutional protection and should not be used in court as a prosecution argument for the existence of consciousness of guilt. So to invoke is still the wise thing to do. Another implication of this ruling may be the following. This decision has led some to argue and recommend that one should always invoke the Fifth Amendment simultaneously with the Sixth. This is because if an individual is clearly and unequivocally invoking their right to legal counsel, asking for a lawyer at the very same time as their invocation of the right to remain silent, courts are more likely to view such invocations as something that cannot be commented upon by the prosecution in court. Well, I haven't had the opportunity to research how empirically true this claim is, but I can certainly understand its rationale. So I do agree that it is wise to invoke Fifth and Sixth Amendment rights together, as my previous video indeed has suggested. So to sum up, one's silence could be used against them if one does not properly and efficaciously invoke their Fifth Amendment rights. Even in pre-Miranda, pre-arrest, non-custodial situations, one should consider invoking their constitutional rights. Clear and unequivocal invocation of the Fifth and Sixth Amendment rights would still be the right thing to do. And as usual, let me end this video by saying this. It is important during police-citizen encounters that we treat police officers with respect, because the absolute majority of police officers are decent, good, kind people doing a tough and potentially dangerous job. We should definitely respect that, but at the same time, we should also know our rights and protect ourselves. The link to the Supreme Court ruling on Salinas versus Texas is in the description box below, and as always, thanks for watching this Ranywayz random video. Please like and subscribe, and I'll see you next time.